Justice cannot remain confined to courtrooms alone, and mediation restores quicker and more compassionate resolutions. These golden words were said by Honorable Justice Surya Kant in an international mediation conference held recently. We are very honored to have Justice Surya Kant amongst us today to grace this special event. Good evening, ladies and gentlemen. I'm Sonia Nigam, advocate on record, Supreme Court, and I'm delighted to host this evening for you. It gives me immense pleasure to welcome you all to the launch of the book titled Commentary on the Mediation Act 2023, authored by Ms. Nandini Gore. We are deeply honored by the gracious presence of our distinguished guests present amongst us today. Our chief guest, Honorable Justice Surya Kant, Judge Supreme Court of India. Our guest of honor, Honorable Mr. Justice K.V. Vishwanathan, Judge Supreme Court. Professor Dr. C. Rajkumar, who is the founding Vice Chancellor of O.P. Jindal Global University and an eminent academician. I also extend warm welcome to the honorable judges, learned senior advocates, legal luminaries, members of the bar, students, mediator community, media and friends who have joined us today to mark this special event. I now invite honorable guests along with Nandini ma'am to kindly join us on the dais. We now move forward to the felicitation of our esteemed dignitaries as a gesture of respect and gratitude. May I invite Ms. Swati Gore to felicitate our chief guest, Honorable Justice Surya Kant. Next, may I invite Mr. Rahul Gore to felicitate our guest of honor, Honorable Justice K.V. Vishwanathan. May I invite Ms. Himani Wadhwa to felicitate Professor Dr. C. Rajkumar. Finally, I invite Mr. Rohit Kumar to felicitate our author, Ms. Nandini Gore. The flower looks very beautiful, and so is this lovely audience. Ladies and gentlemen, now we may come to the most awaited moment of the evening, the formal release of the book Commentary on the Mediation Act 2023. May I request our chief guest, Honorable Justice Surya Kant, our guest of honor, Honorable Justice K.V. Vishwanathan, our distinguished author, Ms. Nandini Gore, Professor Dr. C. Rajkumar, our eminent guest today, and Dr. Vinay Ahuja, Managing Director of Mohan Law House, a leading name in the legal publishing sector, to come together for the unveiling of the book. Thank you, esteemed guests, for unveiling of the book. We now turn to the voice behind this important work. May I invite the author, Ms. Nandini Gore, to share her thoughts on the making of this book, her experiences as a mediator, and her vision for the future of mediation in India. Nandini ma'am.
Respected Chief Guest, Justice Surya Kant, respected guest of honor, Honorable Justice V.K. Vishwanathan, respected Professor Dr. C. Rajkumar, distinguished guests, honorable judges, senior advocate, my friends from the bar, the mediator community, from academia, my colleagues from Karanjawala and Company, members from the media, and most importantly, my family who has gathered here today. A very good evening to all of you. Standing here today on the launch of commentary on the Mediation Act 2023 fills me with both gratitude and humility. This book is not just a culmination of my years of professional experience as a mediator and lawyer. It is also a reflection of my belief that mediation is much more than an alternative to litigation. It is a mindset, a philosophy, and most importantly, a tool for building peace in society. My own journey in mediation began years ago when I got involved in a mediation involving certain community by Supreme Court of India, wherein the mediator was Mr. Sriram Panchu. I experienced firsthand the transformation power of mediation, dialogue, empathy, and cultural understanding. What I witnessed there convinced me that mediation is not only effective but profoundly humane. From that day, I decided to undergo the training to become a mediator, and I attended numerous training lecture classes, outstation conferences, trained the trainer conferences, and never missed an opportunity to attend lectures of great mediators. Since then, I had the privilege of mediating in a wide spectrum of dispute from complex corporate disagreement, intellectual property issues, matrimonial matters, guardianships, and cross-border conflicts. Each case reaffirmed my conviction that mediation is not about imposing solutions, but about enabling parties to find that they can come together in a space of dignity and mutual respect, resulting in a win-win situation for all the parties. I must take a moment to acknowledge the visionaries who have shaped India's mediation movement. As Honorable Justice Surya Kant has often said, mediation is no longer a mere alternative. It is an essential pillar of justice delivery system in a civilized society. His Lordship's thoughts, structural mediation training, and judicial policy has created a cultural shift in how we approach dispute, not as a battle to be fought, but as a relationship to be healed. Justice K.V. Vishwanathan has equally inspired the legal fraternity by emphasizing the role of civil liberties across and access to justice and the constitutional ethos in shaping ADR mechanisms. His words remind us that mediation is as much about protecting right as it is about preserving harmony. Professor Rajkumar, whose visions built O.P. Jindal Global University into a hub of innovation in legal education, has consistently championed mediation as a subject for serious academic discourse, linking it to ethics, justice, and global best practices. To be surrounded by such dignitaries today in this evening is both humbling and uplifting for me. This book is my humble contribution to India's evolving mediation ecosystem. It is written with two objects in my mind: to serve as a practical manual for lawyers, mediators, corporate stakeholders navigating the new statutory framework, and to act as a reflective policy companion offering insight into the doctrine, ethical, and cultural dimension of mediation. I am deeply thankful to Mr. and Mrs. Karanjawala for the unwavering support in my life, in my good and bad days. Cross-cultural communication is very important, and this is the best example where I enter the Supreme Court and join a law firm belonging to a Parsi husband and wife couple. They have always supported me, and from my bottom of heart, I want to thank them today. I also want to thank Mr. R. Santhana Krishnan, President of Nivaran and CLA, for his guidance, Mr. Vinay Ahuja, Managing Director of Mohan Law House, whose faith and commitment brought this book to fruition. On a personal note, my family has been my anchor. My late husband Dilip always encouraged me to write and would have been proud of me today. My children, Rahul, Swati, Himani, my children Rahul, Swati, Himani, and my grandson Adhiraj, whose infectious laughter and innocent smile make life a masterpiece of joy. This book is as much theirs as it is mine. Friends, the enactment of Mediation Act 2023 is a watershed moment in India's justice delivery system. It recognizes for the first time the autonomy of parties, the enforceability of mediation settlements, and the institutionalization of mediation. But beyond the statute, mediation is a reminder of how we choose to treat each other when we disagree. It is about dignity, dialogue, and the courage to listen. My hope is that this commentary encourages more of us, lawyers, judges, students, citizens, to embrace not just the role of advocates, but also the peacemakers, the mediators. I thank each one of you for being here today, taking out time from your busy schedule on a Tuesday evening to honor this book, and for being part of a movement that seeks to make justice not only faster, but also kinder. Thank you so much.
Thank you, Nandi ma'am. You really illuminated us with your pearls of wisdom. We now have the privilege of hearing from one of India's leading academicians, Professor Dr. C. Rajkumar, who is a Rhodes Scholar and an accomplished academic of global repute. Professor Rajkumar has been a pioneer in introducing cutting-edge legal curricula and fostering interdisciplinary learning. Under his leadership, Jindal Global University has been recognized as an institution of eminence by the Government of India and ranked amongst the top universities globally. He has consistently championed the cause of alternative dispute resolution, mediation, and access to justice, encouraging the integration of ADR into both legal education and professional practice. His scholarship, vision, and commitment to innovation in higher education continues to inspire students, academics, and practitioners alike. Sir, may we be honored to please hear from you.
Honorable Mr. Justice Surya, Judge Supreme Court of India, our distinguished Chief Guest, Honorable Justice K.V. Vishwanathan, Judge Supreme Court of India, our distinguished guest of honor, the outstanding author of the book that we are here to celebrate and talk about, Ms. Nandini Gore, Advocate on the Court, Supreme Court of India, distinguished senior advocates, lawyers, ladies and gentlemen. At the outset, I must say that whenever I had the opportunity to engage and interact with lawyers who are, or others who have been in mediation, there is a disproportionately large number of women active in mediation. It reflects the deep sense of inclusivity that mediation has always provided leadership, and women have played a significant role in advancing the cause of mediation. There's no better way to recognize the extraordinary role of women in particular in engaging with issues relating to mediation. At the outset, I want to say that this book is important for a number of reasons. First of all, it's important because of the fact that we have a 2003 Act, and it's important for a lot of people, including young lawyers, also legal educators, students who are in the process of entering the legal profession, to understand the landscape of mediation. So in many ways, I want to begin by saying that what we are understanding through the framework of mediation is that we are somewhat tracing the roots of our historical past. Historically, we know that disputes of all kinds have been mediated. In fact, from village panchayats to community councils, mediation was always part of our cultural and civilizational ethos. Disputes were settled through conversation, conciliation, and compromise, aimed at preserving relationships rather than severing them. Now, it's quite remarkable that the last 2 decades in particular, Indian courts have repeatedly encouraged parties to explore mediation. There have been landmark judgments and court-annexed mediation centers. Our author talked about the work of Sriram Panchu. I had the privilege to know Mr. Panchu for more than 3 decades, and in a very modest manner, we are aware of the work that was held at the Madras High Court through the support of the judges themselves. In fact, it's appropriate to celebrate the contribution of many judges where these mediation centers in its early origins got the legitimacy and the credibility because of the fact that they also received the support of judges and judiciary. Now, these judgments and court-annexed mediation centers played a very significant role in laying the foundation, yet mediation remained a practice-based and fragmented, dependent largely on the goodwill of parties and judges. So what was clearly missing was a comprehensive legal framework, a statutory foundation that could provide structure, standards, and enforceability. And in many ways, the Mediation Act 2023 fills that critical void. Now, of course, we are familiar with the objectives of the Act itself, and one, to make the mediation the first step in dispute resolution process, to institutionalize and professionalize the practice. And that's where universities, law schools also play a very big role, because after all, we are almost 100,000 young people are studying, pursuing legal education in nearly 1,700 law schools across the country. And if we were to develop mediation as a central component of future legal practice, it's important to bring that awareness into our legal education framework. The third objective of the Act was to provide certainty, enforceability, and legitimacy to mediated outcomes. And the fourth was to place India on the global map as a leader in broader aspects of dispute resolution. I'm reluctant to use the word alternative, but let's say the broader aspects of dispute resolution itself. So, when it comes to the major challenges that the mediation is trying to address, one of the things that I've noticed is that in jurisdictions where mediation has been quite successful, enormous effort was made to bring it into the center of legal practice. So, as an academic who does not practice law, as an academic who is not a judge in any form, I am going to give quickly what I believe as 10 major initiatives in India if we were to take mediation seriously. So the rest of what I'm going to talk about is on the theme taking mediation seriously, somewhat of what Dawkins said about taking rights seriously. First, make pre-litigation mediation the default option. Essentially convert tri-mediation framework into a mandatory first step for civil, family, and commercial disputes with narrow exemptions. Incentivize participation, court refunds, including fast-track decrees for settlements, and adverse costs for unreasonable refusals. The metric to assess we have succeeded in this or not is to look at the percentage of filings routed through mediation, the settlement rate, including the time to first session. Second, strengthen and operationalize the Mediation Council of India, empower the MCI as a system orchestrator, setting standards and accredit mediators, regulate ethics, and publish the performance data. In fact, we need to promote partnership with high courts, state legal service authorities, and bar councils to ensure consistency. The metric to assess performance here would be number of accredited mediators and disciplinary actions, and including compliance rate. Third, we need to build a public mediation service network, establish mediation centers in every district co-located with courts and civic centers, launch a national ODR portal for intake scheduling, multilingual assistance, e-sign, and online settlements. Here the metric ought to be to decide to what extent districts have been covered, the wait time to first session, user satisfaction surveys, and things like that. Fourth, introduce strong cost and fiscal incentives. Now, courts should shift cost against parties who unreasonably refuse mediation, provide tax benefits for corporate mediation, use and stamp duty rebates for mediated property settlements. The metric will be to look at uptake of incentives, reduction in prolonged interim litigation. 5. Mediation should become the first government litigation policy. Government must lead by example. Standard ADR clauses in contracts, settlement offices in departments, and approval caps for mediated outcomes. In fact, we need to consider amending the national litigation policy to prioritize and bring mediation to the center stage. The metric ought to be to look at the percentage of government disputes mediated, resulting in cost savings and average resolution time as well. 6. Sector-specific mediation programs. Of course, family law has been talked about it. We need to look at pre-action protocols and child-centric mediation. MSMEs, fast-track vendor dispute resolutions, all these things ought to receive priority. We need to look at infrastructure and construction mediation plus dispute boards for ongoing projects. Insurance and healthcare are specialized areas where mediation panels ought to be promoted. Here the metric ought to be sectoral settlement rates, including recurrence of disputes. In many ways, look at recidivism here. 7th, develop a national ODR stack, build interoperable digital rails for mediation, eKYC, eSign, eStamp, DigiLocker, secure video interactions, and neutral scheduling. Integrate private ODR providers under MCI accreditation. Here the metrics ought to be to look at the percentage of mediations online, average cost per ODR case. 8, build a talent pipeline and professionalize mediation. We need to look at training 50,000, maybe more, of mediators in 3 years with a tiered accreditation from associate to specialist. Introduce mediation advocacy training for lawyers. Integrate mediation clinics across the 1,700 law schools. The metric ought to be to look at mediators certified, diversity of mediators, including by language, region, and sector. 9, to create a trust and awareness campaign. Launch a national campaign explaining confidentiality, speed, and dignity of mediation. Courts to issue plain language, explain orders when referee parties. Develop open dashboards showing settlement rates and average times. You need to incentivize parties to prefer mediation. The metric ought to be public awareness surveys, increase in voluntary referrals. And the last, 10th idea is to establish evidence, learning, and sustainable funding, create a national mediation observatory for research, pilots, and data analysis, establish a mediation development fund, combining union grants, CSR contributions, and court fee shares. I want to end by taking the risk of narrating a short poetry that I wrote before I came here. I am conscious of the fact that I am in the midst of senior lawyers, but I thought I will still share this poetry, essentially about the state of mediation. All right, it goes something like this. Mediation, the silent peacemaker that picked the lawyers. In courtrooms where gavels thunder and echo, mediation tiptoes in like, quote, let's talk, not throw. Clients hug peace, their wallets exhale relief, but senior lawyers gasp, where's my litigation beef? Wait, no long hearings, no daily rate glory. That peace pact just steals away our billing glory. They clutch their files, wear their robes like armor, for billing disputes keeps their ledger warmer. Who needs harmony when hardly revenue sings? Their eyes glint greedily, oh the bells litigation rings. Mediation, calm and noble, just needs a mediator's heart, while seasoned lawyers eye it suspiciously from the start. Calm meetings, tea, no public fray, but what about my fee for the treacherous I slay? They whisper control, prestige, drama, like it's a sacred creed, yet mediation says, take a seat, let's talk indeed. Clients grin as costs shrink, resolution is quick, but many lawyers moan, my billing clock's gone sick. They would rather court chaos, arguments and fights where they can bill like hyperactive, caffeinated nights. But dear litigants, listen, peaceful wins often return with referrals, reputation, and loyalty earned. Thank you very much.
Thank you very, very much, sir. You inspired me here also to try my hand at poetry. Litigation, go away. Come again another day, because mediation is the in thing now. It is now my privilege to invite our guest of honor, Honorable Justice K.V. Vishwanathan, to deliver his address. Honorable Justice K.V. Vishwanathan, may I have the privilege to please say a few words in your praise first? Okay, sir. All yours, sir. Of course, you don't need any praise.
My very distinguished elder brother, Justice Surya Kant, Dr. Rajkumar, Nandini, distinguished senior lawyers, ladies and gentlemen, a very good evening to you. I am particularly happy to be part of this evening's book release. Not only because what is launched is a book on a very important topic, but that the author is Nandini. I have known Nandini for the last 37 years now. Of course, all of us have seen her as an associate in Karanjawala, go on to be a partner, then develop her passion for mediation. But, and I must say this, that she has braved adversity, particularly in the last 3-4 years, channelized the emotion, energy and time to constructively, use it and bring out this work. So I'll be very honest in telling you that I have a sense of personal joy in being a part of this function, and I can see that in most of you, because as the crowd on a Tuesday evening indicates, that only a person who commands a lot of goodwill can enjoy this spontaneous response to an invitation. We are gathered to mark the launch of Nandini's insightful and comprehensive commentary on the Mediation Act 2023. The book, the manuscript of which was sent to me on my request, and I had occasion to browse through it. It's not merely a legal text, it is a powerful statement about the future of justice in our country. As the erudite foreword of Dr. Justice Sikri, former judge of the Supreme Court of India, to the book mentions, in recent decades, India's legal ecosystem has been grappling with a crisis of pendency and delay. The sheer volume of cases pending before courts at every level has long cried out for systematic reform. While adjudication remains the bedrock of the justice delivery system, there is an equally compelling need to foster alternative mechanisms that are accessible, affordable, and empowering. Among these, mediation has steadily emerged as not just a supplement but a viable alternative to litigation. Unquote. The Mediation Act is a transformative piece of legislation that signals a new chapter for our legal system. It's a testament to the belief that justice is not confined to the courtroom, but can be fostered through dialogue, consensus, and mutual respect. This new law, far from supplanting our traditional judicial process, serves to complement and strengthen them, providing a more holistic and human-centric approach to dispute resolution. It acknowledges the deep-rooted tradition of consensus-based conflict resolution that has long been part of our cultural fabric from the time of our ancient panchayat systems. The vision has been championed with immense dedication by a true leader in our legal fraternity, and it is only appropriate that Honorable Justice Surya Kant is the chief guest for this occasion. As the Executive Chairman of the National Legal Services Authority, Justice Surya Kant has been instrumental in placing mediation at the forefront of our national discourse on access to justice. As he so eloquently stated, if courts represent the authority of justice, mediation represents its humanity. It restores agency to the parties, transforms conflict into cooperation, and turns adversaries into partners in resolution. A prime example of this vision is the significant 90-day nationwide Mediation for the Nation campaign launched by NALSA in collaboration with the Mediation and Conciliation Project Committee. This initiative, which commenced on 1st July 2025 and slated to conclude on 30th September, is designed to resolve pending cases across all judicial tiers, from the district courts to the high courts. It champions mediation not just as an alternative, but as an effective, cost-efficient, and expeditious method for restoring harmony and social balance. These initiatives are a testament to the belief that justice must not be a privilege but a fundamental right for every citizen. And it is this very belief which resonates in the thoughtful preface that the author has penned to the book, and I quote, "Mediation for me has always been more than an alternative to litigation. It is a mindset, it is a conscious commitment to dialogue, dignity, and de-escalation. The qualities that make a good mediator, namely empathy, neutrality, cultural awareness, and emotional intelligence, are often cultivated outside the courtroom, yet are deeply intertwined with the ethics of our profession. Over the years, I have come to understand that mediation is not about imposing a solution, but about facilitating a space where parties can find one themselves. You would have read many articles on mediation, but what this book stands out for, and I want to emphasize that part of the book, is that the author takes a forward-looking view by examining the role of artificial intelligence in mediation. The author identifies several advantages of AI first in mediation, including enhanced efficiency by reducing time for research and documentation, cost reduction by lowering legal fees, improving impartiality through data-driven recommendations, and increased accessibility for those in remote areas. This is supported by examples of Brazil and Indonesia that have leveraged AI-driven mediation. But the author doesn't stop there. He also warns of the pitfalls that AI-driven mediation can involve. The author's primary concern revolves around the challenges and ethical considerations. These include the lack of human touch and emotional intelligence that human mediators provide, crucial data privacy and security issues given the sensitive nature of mediation, and the risk of algorithmic bias perpetuated from the training data. The overall emphasis is on the need to balance technological innovation with human-centric dispute resolution, highlighting that regulatory oversight and ethical guidelines are key to harnessing AI's full potential. As we move forward, it is imperative that the bench, the bar, the business leaders, and the common citizens embrace mediation as a transformative philosophy of justice. Nandini's commentary is a culmination of her lifelong dedication to advancing peaceful, accessible, and efficient modes of justice, and her work is a true gift to the legal community. I congratulate Nandini for this book, and I wish her many more books to her pen. Thank you very much for your time this evening.
Thank you, sir, for your inspirational words and enlightened guidance to all of us. It is now time to hear from our chief guest of the evening, Honorable Justice Surya Kant. Honorable Justice Surya Kant is a jurist deeply admired for his integrity and unwavering commitment to social justice. Justice Surya Kant, please.
My brother Honorable Mr. Justice K.V. Viswanathan, Judge Supreme Court of India, Professor C. Rajkumar, Founding Vice Chancellor of O.P. Jindal Global University, the actual chief guest of the event, Nandini Gore, office bearers of the Supreme Court Bar Association, Pragya and Vikrant I could see here, Shri Nayyar, Mr. Jain, President and Secretary of the SCORA, very eminent mediators whom I keep on interacting and meeting on different occasions, particularly the events which are going on in these days, a galaxy of senior advocates from the Supreme Court Bar, members of the Supreme Court Bar Association, family members of Nandini ji, ladies and gentlemen, friends from media, a very good evening to all of you. Two things are in these days bothering me a lot. One, the convocation of national law universities. I am committed to deliver 9 convocation addresses within 3 months. 3 I have finished, 6 are in pipelines. And second, my frequent speeches on the subject of mediation. Why I said that bothering is because I keep on wondering that I need not to repeat myself. And it's very difficult to find out some new thoughts and ideas to speak before and eminent persons like you. My friend and brother Vishwanathan has pointed out the initiative which we have taken under the banner of NALSA and MPC, the Supreme Court Mediation Committee. We have launched the program of Mediation for Nation that commenced on 1st July and will be ending on 30th of September. I can with proud cooperation and the kind of commitment the team of mediators throughout the country have shown, I may just for encouraging everyone share the data that by now 1.69 crores matters have been identified which are most fit for mediation. These matters have been referred to different mediators. When we started this, I would say, movement, we had only 11,000 trained mediators throughout the country, but with the initiation of online training programs, we have added 8,000 more and 4,000 are right now under training. With the addition of these 12,000 more mediators, we will have a mediation family of more than 31,000, and I am quite sure that with their commitment, dedication and support, the mediation will indeed prove to be the game changer. Let me begin by asking all of us, including myself, 3 questions. 1, what does justice feel like for the ordinary Indian? 2nd, is it simply winning a case in court regardless of the time and the money invested? And 3, or is it about ending a dispute with your dignity intact and a sense of contentment even if the outcome was not so perfect? Each of us has witnessed how the weight of pending cases can strain families and businesses. Our courts strive hard each day to deliver justice, but the adversarial system can often and result into a grueling, daunting, at times even dehumanizing experience. There comes a moment when the soul of justice itself calls for renewal, for a humane, accessible, and empowering alternatives, where disputes are not defined by who wins and who loses, but where the disputes are resolved by allowing the people involved to walk away content and acknowledged. As an advocate, and of course as a judge, I have witnessed this growing need not only in the grand halls of the Supreme Court, but in the quiet offices and homes that make up our country. That is why today, as we celebrate the launch of Nandini's book, Commentary on the Mediation Act 2023, I am convinced that this is much more than a book unveiling. This commentary showcases our newfound vision for the Indian justice delivery system, a vision that is deeply personal to me, shaped by over 40 years spent at the bar and bench. We all know very well that mediation at its heart is as old as Indian civilization. Professor Rajkumar very briefly and very eloquently explained it. Our grandparents invoked the panchayats, where community elders met in public areas to resolve disputes through the power of dialogue. Today, mediation carries legal status, but its spirit endures as a voluntary and collaborative effort grounded in listening and mutual understanding, focusing always on the human behind the dispute and their human needs. For instance, a very recent example of Mysore property disputes among the family members of the rulers, where the daughters were sought to be deprived of their share. The mediation through the District Legal Service Authority of Mysore brought the family face to face after decades. With the help of these trained mediators, the disputed property and funds were equitably distributed among legal heirs including the daughters. What had seemed impossible for years happened in a day simply because mediation provided a space for empathy, listening, and compromise. This is the miracle of mediation. It embodies the human dimensions that sometimes long-drawn court battles can lose track of. In the simplest words, if I am permitted to say, the value of mediation lies in the primacy it provides to three things. One, empathy, listening not only to the words but to silence also. Second, dignity, ensuring everyone feels respected. And third, creativity, finding paths for resolution that litigation might obscure. Its triumph is not just in achieving a settlement, but in resolving an issue between people in a way that allows them to continue having relationships, whether personal or professional, with each other and for a long term. Mediation is not just a tool to resolve disputes in presentia. Let's understand its importance. It is also a safety valve against future acrimony among the warring groups. Research from around the world affirms that we have always intuited mediation works best where relationships matter in families, businesses, and communities. The regional mediation centers and initiatives in our country have resolved many commercial disputes worth crores of rupees, reunited couples, protected children, eased workplace tensions, and restored neighborhood harmony. It is precisely to nurture these successes and enshrine their values that the Mediation Act of 23 has been enacted. By creating a unified statutory system, the Act has made mediation agreements enforceable, giving true meaning to the word resolution. It also promotes the idea of dialogue before confrontation by mandating pre-litigation mediation for a slew of civil and commercial disputes. Most importantly, this Act protects confidentiality and supports the party-driven nature of mediation so that outcomes remain in the hands of those most affected. Taken together, these features transform the character of Indian dispute resolution from a system preoccupied with winning and losing to a system oriented towards settlement, compromise, and maintaining future relationships. Given the ambition of the Act, any commentary on it cannot be termed an ordinary treatise. And thank you, Nandini, for taking this initiative. This commentary is shaped by policy engagement, informed by comparative insights from Singapore to California, and grounded in the real experiences of Indian families and businesses. What I found most unique about it is that it illustrates ethical dilemma and real-world scenarios to properly shape the reader's understanding of the subject. Instead of simply telling the reader about the correct course of action, the book explains how to drive such a path based on the specific needs of the situation and the people involved. To me, this book is an open invitation to lawyers, judges, policymakers, and citizens to embrace mediation not as a second-grade alternative, which I keep on openly speaking, but as a mindset. In the past few months, as I said earlier, I have spoken a lot about mediation and its importance. I said that instead of alternate, it should be the preferential treatment. I also spoke that instead of speaking in the legal language, let it be translated into the vernacular language, in the language of the common person, in the local dialect, and let it be taken and let us reach out to the villages where I am very soon introducing the community mediation concept also. I have spoken a lot about mediation and its importance, so much that some of you might even call me mediation obsessed or frankly be bored with the topic. But let me share. I am happy to deliver even more 4, 5, 10 speeches if it helps in any way to convey how necessary this change in mindset is. Dear friends, beyond law and legislation, mediation asks us to see each other not as adversaries, but as amiable neighbors or colleagues. The Mediation Act and this commentary released today will act as a tool for those who choose to listen rather than to judge. As we look to the future, my sincere hope is that this commentary finds its way into the hands of those who shape our laws, policymakers, judicial officers, law practitioners, and the next generation of legal minds. If this work deepens our understanding of mediation and enhances future legislation to make our justice system more humane and accessible, then its purpose will be truly served. I believe it will ensure that mediation in India continues to evolve, reflecting not only the latter, but the spirit of justice our society richly deserves. In the last, only one explanation, Professor Rajkumar read a poem that about the lawyers. I must share with him that mediation today is coming, as I said, the game changer, as the future hope, as the solution for the present. It's only and only because of the extraordinary cooperation rendered by the legal fraternity, the lawyers, particularly the senior lawyers and the mediators. And thank you very much, all of you. Thank you. Jai Hind.
Thank you very much, sir, for sharing your profound insights and deeply enlightening words with all of us. To formally conclude the event, may I now invite Ms. Himani Wadhwa to deliver the vote of thanks. Thank you and a very good evening to all.
Respected Chief Guest, Honorable Justice Surya, Guest of Honor, Honorable Justice K.V. Vishwanathan, and distinguished academician Professor Dr. C. Rajkumar. It is truly my privilege to extend my heartfelt gratitude on behalf of the Gore family to each of you for gracing this event today. Your presence, your words of wisdom, and your inspiring reflection on the role of mediation in India has really added to value to today's celebration. We are equally grateful to our publisher, Mr. Vinay Ahuja, Managing Director of Mohan Law House, and their team for their commitment and support in bringing this work to fruition. I would also like to extend our sincere thanks to the media, whose presence and coverage have ensured that the message of mediation reaches a wider audience. Mr. Gopal Singh, we would like to thank the Secretary of Niti Bagh Club for convincing us that this is the right platform for the inauguration of the book, and truly so. Lastly, to all the members of bar, bench, academia, students and well-wishers present here, you have made this occasion truly memorable. I thank you all warmly and invite you for high tea outside. Thank you.